who acts under law or the constitution. This court has held that it is subject to structuring and regulating that discretion. There cannot be an exception for the Chief Justice alone. Now, there is a petition that is pending before this court, CP number 15 of 2020, filed by the Islamabad Bar Association. I was appearing for the Bar Association in that case. This has been pending since 2020, and there is a specific prayer in this and the ground that this discretion of both Chief Justices, not just the Supreme Court, but also of the High Courts, it needs to be structured and regulated so as to improve public confidence.
Salahuddin, you have given two options
Yes.
to this court to resolve the issue.
Yes, sir.
What do you say about the right of appeal?
My Lord, as far as the right of appeal is concerned, I believe that it did require legislative intervention.
Legislation by
Parliament.
two-third majority?
Sorry, my Lord.
By two-third majority? Because it
No,
is
sir. By a simple majority.
184(3) is a constitutional provision.
Yes, sir.
And appeal is continuation of the original jurisdiction. How this legislation can create a right of appeal against a constitutional provision originally, which is part of the constitution?
Well, if your lordship will allow, if you will give me 2 minutes, I'll wrap up this part and then come to that, because I have detailed submissions on legislative. Ji, sir. In any event, sir, as far it was not done on the judicial side either. It was in those circumstances that the Parliament eventually acted. Now, lastly, I'll just say this, sir, that there are 5 fundamental issues with.
I think you would not disagree that the Parliament legislates. Even the Constituent Assembly legislates. But the interpretation is the exclusive domain of this court.
Absolutely. Absolutely.
The Constitution says that, the court says that, and the judgments say that, and it's a settled principle all over the world.
Yes, sir. No trouble.
So can the Constitution, can the legislature turn around and say, well, the interpretation of a constitutional provision that the Supreme Court has done is incorrect, and that by ordinary legislation we are going to correct it? Can it?
No, it cannot. But my submission is that this court, while asserting the mastery of the roster in the office of the Chief Justice, has not interpreted any specific provision of the Constitution. They have relied essentially on the Supreme Court rules, and those rules are subject to law, and I'll come to that.
So while there is legislation, is the Supreme Court now prevented from making rules on the subjects or the areas that have been legislated on?
Yes.
So that now the Supreme Court cannot make any rule on that.
It can make rules to further that legislation, and it can make rules on anything that is not specifically covered in that legislation, but the legislation has primacy.
So, from what you say, Mr. Salahuddin, a part of 191, and I would say the heart of 191 becomes redundant.
I would humbly differ with your lordship.
Because
I read 191 differently.
Simple reading of the 191 essentially confers a power to frame rules on the Supreme Court and not on the Parliament or any other organ. So when you say the Supreme Court cannot, now that a statute is in place, proceed to exercise its powers under 191 and frame its own rules or extend its own rules or modify its own rules, you're essentially saying that the 191, as far as the powers of the Supreme Court is concerned, has become redundant.
No, sir. As I said, there are areas that this court still can, but the area where a law has come into force, then it is subject to that.
Section 8 has come. Has that not affected an implied repeal of certain portions of the Supreme Court rules?
My lord, I don't think it does
as it has said, notwithstanding anything to the contrary contained. So
In
if
the
there is any
rules.
conflict, and it specifically refers to rules, the only rules that are relevant here are the Supreme Court rules.
Yes, sir,
No, no.
certainly.
So if there is any conflict, then that would be a conflict with Section 8, which would override. So there would be an implied repeal, I'm putting it politely. So there could then be an express repeal. Tomorrow an act of parliament could be made saying Section Falana, the Supreme Court rules 1980 are hereby repealed. Would that be within legislative
Lord,
competence?
in my opinion, it is within legislative competence, but if the effect and the substance of that law is to impair in any manner the access to justice, then it's a different issue.
thing.
But legislatively, they can.
They can do
They can. Now, my lord,
Mr. Salahuddin, please read section 2, subsection 2. Please read that of the act, which
Jeez.
is impugned before us.
सर अगर इजाजत दें ये वाला
ये-
लेग खत्म
ये
करके
जरा
फिर
पढ़-
मैं वो
please ये
provision-
जरा पढ़
जी
लीजिए।
मैं पढ़ लेता हूँ सर, पढ़
इसी
लेता
के साथ related है,
जी,
इसलिए आप read
हूँ मैं अभी पढ़ लेता हूँ Section 2, subsection 2, soon after commencement of this act, the committee constituted under subsection 1 shall hold its first meeting to determine its procedure.
बस यहाँ
जी,
पे
सर।
if suppose this enactment succeed, the again procedure has to be constituted by the committee.
Yes.
So the same procedure, which is the brainchild of 191, again has to be exercised by the committee. So the definition of Supreme Court, that so Chief Justice and judges would not compromise.
My lord, as far as I
Here,
understand the
you
word,
see, in the spirit of 191, the whole the court is supposed to make the rules, but here only there are 3 persons to make rules. What do you say about this?
जी sir, as I read section 2.2, when they talk about procedure, they are not talking about the procedure of the court. They are talking about the procedure of the committee, how it will hold meetings,
Yes, of
how
course,
it will
of
do that.
course.
So that power is not about the procedure of the court mentioned in 191. That is an internal arrangement of that committee to decide how often we will meet, whether it's every week or once a month or what, so on and so forth. So
But how
that
do
does
you-
not impact. the
How do you
191.
determine that this is an internal matter for the Supreme Court to decide, as opposed to this is a matter which can be legislated on? As per your argument, once it is legislated upon, they have competence, they can legislate. The Supreme Court then cannot make any rule contrary to that. So they can make whatever, wherever they want to legislate, they go ahead and do so. But how does one then determine that this falls within the internal matters of the Supreme Court, hence no legislation, and this doesn't fall within the domain of the internal matters of the Supreme Court, hence you can have legislation? I mean, you just seem to be placing more conditions than you are in explaining how you're giving competence in a simple way. हर चीज को आप कंडीशन करते जा रहे हैं कि ये फिर ऐसे देखा जाएगा फिर ऐसे, तो that surely can't be the
And you
purpose
see,
and intention of the Constitution.
Mr. Salahuddin, there are 2 things. This section 3 and section 4 is actually dictating the Supreme Court. In the matters where interpretation of constitutional provision is involved, the committee shall constitute a bench comprising of not less than 5 members. It is a dictation to the Supreme Court or to the committee. Likewise, in 3, it says it shall constitute a bench of not less than 3 members. It is dictating the Supreme Court. Then, section 8. Look at the expense of section 8. Provisions of the Act shall have effect notwithstanding anything contained in any other law, rules, regulations for the timing and force or judgment of any court, including the Supreme Court. Now, where the Supreme Court has interpreted the Constitution, as I earlier said, and has set down certain rules or has interpreted the constitutional provisions, this act, 8 Section Act, I mean, it wipes away everything and goes on to dictate the Supreme Court as to how to conduct its business. If this is not a violation of the principle of separation of powers and interference in the independence of the judiciary, what else is?
Lord, firstly, I'll submit that Section 8 is the kind of non-obstante clause that is present in numerous statutes. Now, the thing that is to be seen, and I agree with your lordships, that if your lordships have interpreted the Constitution, Parliament cannot change that interpretation. On the other hand, there are three types of powers that this court generally exercises. One, you interpret the Constitution. On the other hand, if you interpret a mere statute, again, Parliament cannot override the judgment, but it can change the statute itself.
We have said this is a constitutional convention. Which category would you bring it? Would you bring in Molasses case and say, okay, we have changed the convention and therefore it goes?
I have
Provision. When you're dictating, the Parliament is dictating the committee. It could have dictated the Chief Justice. It is now dictating 3 judges. What prevents it from dictating the Supreme Court?
My Lord, with respect, I would not frame it in that leaden kind of terminology of dictating, but the court.
If you would just explain to this bench whether the Parliament is competent to legislate or not. If it is competent, then let us respect the Parliament and not view this as a dictation. It's a law, then competently made. So look at this in that view. But first, whether it is competent to legislate.
So I'll now move on to the competence.
No, I just had a related observation. At the moment, we are looking at everything, nothing has happened. What may have happened, what may happen, what the pitfalls are, we are assuming those. I mean, give us this much credit that maybe whether the use dictation is used or any other word is used, may please, if the word please had preceded it, would have made a difference. The question is, this law, one way would be to let it function. And then in its functionality, you may still not be satisfied, or someone may not be satisfied and say, okay, you have not abided by the law. That question, I mean, we are assuming that we are not capable of manning this ship. The only thing is that previously there was the sole pilot. Now there are 2 co-pilots, maybe in determining things go wrong. Maybe that's a possibility. After all, for instance, when the Chief Justice leaves the country or falls ill, the acting Chief Justice comes in and he assumes the power. So why are we scared of our own shadows? I mean, the co-pilots, if they are there, why we are all assuming that we are leading to the iceberg which lies underneath? Nothing has happened so far. So we are actually, it's all conjecture and surmises we are based on. And the only real question comes down to is the competency. Well, that's the only real question as I see it, which Ijaz Sahab had asked on the very first day. The focus on that. Either you can make the law, you can't make the law. Now, what may or may not happen, and whether you call it dictation or you call it a request or you call it whatever you want to call it, better way of doing business, being more inclusive, participatory, transparent. I mean, you can give it any adjective or use before that. At the end of the day, it's simply, can they make the law or not? If we even accept that this challenge lies under 184.3. Just going ahead and saying, yes, okay, it lies under 184.3. Just tell us that this law is constitutional. That's all.
Yes.
And whether it may not work tomorrow, and then again, people will keep challenging it. I mean, people move applications under whatever, Order 26, whatever of the rule, Order 33, where the rule prescribes something to do in a particular manner, they move an application. I could not do so. Please condone this. I mean, I don't know how you're going to interpret it when it comes up. So we don't want to tie our hands down how the future will be interpreted. I will come back to Ijaz Sahab has been asking, there's only one question, is competency of making this law. The-
My lord, I move directly to competence. Now, legislative competence of the parliament may arise in at least two ways. It may arise through reference to Article 142 and the specific entries in the legislative list, or it may arise through direct authorization by some or other provision of the Constitution. This court has recognized that. I think Mr. Bandhari had also referred to it, Province of Sindh versus MQM. That is PLD 2014, Supreme Court 532 at paragraph 62.
2014 Supreme Court.
532 at paragraph 62.
ये दिखाइए जी। Citation 532,
Yes, sir.
2014 Supreme Court.
नाम क्या है केस का?
Province of Sindh versus MQM.
ये डिलीमिटेशन वाला
3-1
केस है,
531 है।
जी,
लिमिटेशन।
जी, बिल्कुल। इसका relevant paragraph 62 है, sir. और इसमें सर, I don't want to read this whole para to save time, but if your lordship sees about the third line from the bottom of the page, 577, when the main body of the Constitution provides for competent legislature, it is not necessary to look into the legislative list. And इस paragraph में फिर कई मिसालें दी गई हैं कि कहाँ डायरेक्ट कॉन्स्टिट्यूशनल प्रोविजन ने ऑथराइजेशन दी थी, कोई कॉरेस्पॉन्डिंग एंट्री फेडरल लेजिस्लेटिव लिस्ट पे नहीं थी. अब in my concise statement in paragraph 31, I've given about a dozen examples. I'm not going to take your lordship's time right now, but para 31 mein I've given a dozen examples where parliament is given power to legislate on subjects which are not covered by any legislative entry.
What is the answer over here in this case?
Over here, my reliance will be 191. 191 in the cases of 2, 3, 4, 6, 7, and 175(2) in the case of section 5.
So how do you read subject to?
Yes, I'll just come to that, but if I may first complete this.
So you're not relying on entry 55.
Entry 55 is relevant as far as 175(2) and the appellate power is concerned. I do not believe that entry 55 is relevant as far as practice and procedure are concerned.
Also not 58.
58, I will be relying upon.
You will be.
Yes, sir. Because my view of 58 is entry 58, and I was just going to come to that, is different from what has been expressed by your lordship. My view of 58 is that after the 57 previous entries, which deal specifically with a particular subject matter, have been dealt with, 58 is a catch-all kind of provision.
Does it confer legislative competence?
What it does is, sir, it recognizes, it does in the second part. In the first part, what it basically recognizes is that there will be things in the Constitution that directly authorize the Parliament. So wherever it does that, that is within its legislative competence. So that is the part which says, if I can just read. Matters which under the Constitution are within the legislative competence of Majlis-e-Shura, Parliament. Now this is meant to cover as a catch-all kind of thing, those direct constitutional provisions.
And then it is followed by 59.
Ji,
So
sir, if
we
I
should read 58 totally independently and
Sir.
not give it a restrictive
Yes.
meaning as 59 would indicate.
Exactly.
If 58 wasn't there,
Yes.
then we are left with 59.
Yes.
then you are saying you could be in trouble.
Yes.
The law could be in trouble.
Exactly.
Otherwise, flesh it out.
To this. And then is there also the part that or relate to the federation. And that is another broader catch-all kind of entry, which recognizes that there may be things that we have missed out in the earlier 57 entries. If by reading of the text of the Constitution, it is clear that a particular subject or a particular field would naturally vest in the
The
federation.
number of judges in the Supreme Court is fixed by Act of Parliament or presidential order. The number of judges in the High Court is fixed by law
Yes.
and or presidential order. Law over here would mean what? Would it relate to entry 58 or relates to the federation?
In 193, the number of judges
In the
of the High Court.
where it says law. Now, would it be covered by this latter part or relate to the federation?
My lord, I would, for the High Courts, as far as I know,
No, but
there have been provincial legislation.
that's what the point I'm making. That it does certainly relate to the federation because under our system, under the constitution, our constitution, unlike say the US constitution, we don't have separate federal court system and state court system. One unified court system applies both federal and provincial law. So insofar as high courts are concerned, in one sense it does relate to the federation. But as soon as you say that, you remove the provinces.
My lord,
And if you remove the provinces, well, provinces can say, well, wait a minute. I mean, high courts surely have something to do with us. So it's not that simple. You see, that's why I'm saying, that's why I was putting it to you. But I understand you disagree that this is a negative point. You say no, it confers legislative competence. I understand your point.
my lord, I'm grateful. Now, my submission, of course, is that Article 191 is a standalone enabling provision. Read with the first part of entry 58, it is more than enough to confer legislative competence on part of Parliament. And moreover, the Supreme Court, and I appreciate your Lordship's point about the difficulty of the High Courts, and there is, in a sense, in fact, even our provincial courts, also the CRPC, and there are numerous.
राउदीन साहब, उसमें देखिए एक और एस्पेक्ट था कि वो जो 191 का इक्विवेलेंट है फॉर द हाई कोर्ट्स, वो क्या है 201 या
जी सर,
उसमें आप देखिए एक और एस्पेक्ट था, उसमें प्रैक्टिस एंड प्रोसीजर की बात हो रही है ना, हाई कोर्ट की प्रैक्टिस एंड प्रोसीजर, लेकिन देयर इन द कंकरेंट लिस्ट there were specific legislative competences with regard to procedure, civil procedure, criminal procedure. So the position of the high courts were in the context of 201 is perhaps some different from the position of 191, where, as you have noted in your, I think, submissions or something, under 56 Constitution, 62 Constitution, there was specific legislative entry for the Supreme Court, which has been taken away.
Yes,
ये एक बड़ा इसमें एक एस्पेक्ट है ना इसके अंदर कि आप देखिए कि law over there for high courts was not just any equivalent, or I don't think actually there's any equivalent to 58 in the concurrent list, but it could be related to specific legislative competences.
Well,
यहाँ पे एक बड़ा फर्क है ना, आप जरा काइंडली इस पे थोड़ा एक्सपैंड करिए। इशू इतना आसान नहीं है ये, this is a complex issue which has many ramifications.
Well, Lord, the other submission that I was making is that regardless of the case of the High Courts, the Supreme Court at least is undoubtedly a federal institution. It relates to the federation. And therefore the second part of entry 58 would also come into play. Now, I've already submitted that as far as I'm concerned.
Can you repeat this point? I didn't quite get it.
So, matters which under the Constitution are within legislative competence of Majlis-e-Shura or relate to the Federation. So, matters as far as the Supreme Court is concerned and its practice and procedure, etc., that is obviously a matter that relates to the Federation. The Supreme Court, there might be a different view or a concurrent kind of thing as far as the High Courts are concerned. But at least as far as the Supreme Court is concerned, it is a federal institution. It relates to the Federation. Therefore, it is even otherwise covered by the second part of entry 58.
How will you
The
reconcile?
other issue about the High Courts and the Supreme Court, this problem which we are facing in the Supreme Court, the High Courts, to the best of my understanding and knowledge, and even when I was practicing law, this problem was not faced. The problem faced by litigants mostly was that my case is taking forever to be fixed. But I never came across this matter of which cases would suddenly pop up and there would be an urgent application, it would be granted or not granted, and all the other cases would stand in queue, wait for the turn to come up. So would it be correct in saying the high courts are better run than the Supreme Court? I know you may as counsel not be able to say this, but I, as a Chief Justice, may pose this question that, I mean, in Bulusan, I never had this problem. No lawyer even complained or even suggested or ever wrote or application was submitted that of this nature that, my case is being, for bench specific cases are being made. I mean, there was the criminal bench, there was the constitutional bench, there was the other benches, single judges benches, the company judge, and they would rotate after once in a while. And this issue, at least I as a Chief Justice never faced, and as a lawyer, practicing lawyer mostly in the Sindh High Court, but elsewhere as well, did not come across this problem. Is there such a problem in the High
My
Court?
lord, to be frank, it depends on High Court to High Court and Chief Justice to Chief Justice and the Chief Justices of this court. And that is precisely the rationale for this law, that it should not depend on Chief Justice to Chief Justice. There should be some kind of framework and structure that is.
And the only other thing which,
Committee to committee.
and I would only change it, one more thing I should add. And the other reason why that problem does not exist is because there is a forum of appeal. You're not happy with a High Court appeal, HCA judgment, or an inter-court appeal judgment, or a judgment, you have a forum of appeal. So that problem does not exist. So here the problem has culminated with a number of factors: accumulation of powers, the random exercise of power, the non-transparent manner of operating of power, the excessive use of 184(3), going into matters which are very private and individualistic or maybe not within the domain. So a combination of these factors has resulted in this act, in the making of this act, to impute some malafide to Parliament. I think that would not be fair at all, because lawyers have been in the forefront of asking for this kind of, maybe we're left with the mode and manner of who does the law. Even I haven't heard anyone from the petitioner side saying that's fundamentally wrong in this law. So all they're left with is basically, again, competency, who makes this law and who's authorized or constitutionally authorized to make this law. So the problem was created, maybe, and this is Parliament's effort to maybe resolve the problem.
Sir, agree, sir, that our grievances in respect of the High Courts are somewhat less intense, because we can always knock on your doors for correction. We don't have that option available here. But just to add on to your lordship's observation of it may vary from committee to committee, and yes, it may. But the thinking.
Surely the solution is, logically, give the power to the full court, which is where presumably it always lies when the court makes its own practice and procedure. Because you see, you started out with internal independence and all of that. फिर internal independence का तो एक ही logically एक ही हल है ना जी, कि भाई अगर if the court, and I'm not saying I agree with this, because with very great respect, I definitely have a serious reservation with things being imputed to retired chief justices. Random, this, and with all due respect, sir, this is not proper. We should not impute things to those who cannot defend themselves sitting in open court. We should not do this. But anyway, let me move on. So logically, the conclusion is that the matter should be placed in the hands of the full court, because otherwise there is never any internal independence. But the matter doesn't even end there, because full court always decides by majority. So logically, the minority is always in thrall of the majority of the full court. So then logically, the answer would be that